Hello, and thank you for joining us for what we plan to be a highly educational webinar. Today's theme is Managing Crisis in Conflict Minerals Supply Chains. The objective of our speakers today is to provide you with pragmatic insights that will assist you in managing your responsibilities for conflict minerals compliance within your companies. We want to start with a bigger than conflict minerals view of lessons learned by others about managing crises in extended supply chains. Rob Kassmeyer, president of Green Status Pro, has been a C-level executive in manufacturing companies for over 20 plus years. He has managed through several supply chain crises and very much wants to share his experiences and perspectives with you. Next, Anthony Brewer of Ernst & Young will update us on how to prepare for the Independent Private Sector Audit. While the IPSA is a year away for most, now is the time to implement the required policies and procedures. Anthony is a professional who will provide you with reasonable and pragmatic advice on best practices. I'm John Logan of Green Status Pro. I'm looking forward to showing you how and why we are currently in the midst of a crisis in conflict minerals reporting. The issues we face are accurately preparing our 2014 RCOI reports despite a wide variety of challenges. Housekeeping. As you've heard so often, please submit your questions at any time, and we will provide you with our responses after all the presentations. And of course, the presentations will be emailed to you by tomorrow. Thank you for attending, and with that, Rob, will you start us with lessons learned from the extended supply chain failures?
Thanks, John. I'm going to address supply chain crises that are all too often from extended portion of a company's supply chain. We'll talk about what that means for companies and how best to manage these issues. Responsible sourcing pressure is mounting. We all know this. Legislation requiring supply chain transparency is driven by voter concern, and it directly impacts a number of corporate stakeholders. In responding to such sustainability issues, companies typically focus on their core operations and their adjacent tier, either direct customers or direct suppliers. These organizations typically have regular communications on many levels and are typically not the source of sustainability crises. The extended supply chain can be several tiers removed and incorporate distributors, trading companies, and other intermediaries. Your extended supply chain typically receives little visibility or attention and is the area of most risk. So let's look at 5 recently well-publicized cases. Number 1 is auto and appliance companies were totally unprepared in 2006 when they found that some steel that they were purchasing used a pig iron supplier that incorporated Brazilian charcoal that was made by slave labor. What a shame. This caused a lot of C-suite attention, as you know if you are in those industries or can imagine otherwise, by virtually all industry participants for extended periods of time. 2 companies, Ford and Kohler, stopped purchasing from affected suppliers immediately. Similarly, in 2007, Mattel was caught flat-footed when lead paint was found in some of their toys. They had used a regular contract manufacturer, who had bought a certain paint from one of their regular suppliers, but that one had bought lead-based pigment from another supplier that had falsely stated that they had not incorporated lead. Obviously, this led to a costly recall, a significant brand hit for Mattel. Gibson Guitars was shut down by the U.S. government both in 2009 and again in 2011 for importing ebony wood from Madagascar and India. This resulted in loss of business and materials involved, as well as fines and significant brand deterioration. In 2013, the Rana Plaza collapsed in Bangladesh. This building housed a number of contract garment manufacturers and resulted in over 1,100 deaths, many more injuries. Inappropriate material had been used to make the factory. Inadequate inspections had taken place, and The workers had been forced to work despite growing cracks in the walls. Walmart, Benetton, and a number of other well-known clothing brand retailers were not prepared. Since then, they've funded a $15 million support for victims and their families, and have funded inspections of 2,300 of the 6,000 garment factories in Bangladesh. Lastly, this year, striking closer to home for a number of us, was a much smaller crisis, but since it strikes home to conflict mineral people, I put it in here. Some 68 companies filed to the SEC that they were potentially sourcing gold from a supplier in sanctioned North Korea. Amid negative publicity, boards and C-suites drove compliance officers and associate organizations to rapidly resolve the problem, and basically what amounted to the removal of the corporate embarrassment and hopefully the PR disaster. At this point, the SEC has not charged anyone. So if we look at these groups, lessons learned from these extended supply chains issues are similar. Number one, these crises are all from remote areas of companies' supply chains where there's no direct communication or even awareness of the particular problem that's occurring or developing before it occurs in most of these companies. Number two, long and short-term impacts are significant. These include brand damage, out-of-pocket costs, loss of life and jobs, as well as personal disasters for individuals and obviously disruption for the companies. Next, substitution is a typical response. This is a quick response that often causes unfortunate, unintended problems. The net is that supply chain turmoil is irregular in occurrence, but explosive when it happens, and the incident levels are growing due to the legislation. Moving forward, best practices are to adopt a sustainable approach of anticipation, integration, automation, and communication. Simply put, these policies should be put in place with procedures to help identify and mitigate extended supply chain risks. You have to realize that you're not alone. Draw on available resources. They're out there. Automate where possible for accurate, cost-effective, and rapid information on which to act, and communicate through the supply chain as well as with stakeholders. So summarizing best practices, use 2014, the last year of transition for conflict minerals for most companies, to develop effective risk management and then roll out the tested procedures in 2015. The 2014 approach should be directed at going deeper, not broader, in your supply chain. Prove the approach, broaden it next year. Learn to communicate effectively through the tiers. Next, automate, automate, automate for accuracy, speed, and cost effectiveness. And lastly, use gap or readiness assessments or so-called mock audits to identify problems and solutions. Now, Anthony will be talking about the audits and the gap and readiness assessments, and then later on John will be talking about the automation facts as we go ahead. Thank you. Anthony, do you want to take this on?
Yes, thanks, Rob, and thank you, John and Green Status Pro for hosting. I think this topic is very well timed because the Independent Private Sector Audit, or the IPSA, or we can just call it the audit today, has rapidly come into focus for many SEC registrants that are subject to the conflict minerals rule. And I think that that change in focus is for a couple of reasons. First, obviously, the timeline. The rule provides for audits in the third year of compliance, and well, we're kind of snuck up on us, but we're more than halfway through year 2 now, 5, 6 of the way. It's flying by, so people are starting to think ahead to the next compliance year and what an audit might look like. Second, there are other sources of uncertainty surrounding the audit in terms of what it entails, how it will be triggered, and so forth. That second reason, that uncertainty, I believe is more relevant to what I think people want to hear about. Everybody knows it's coming, although there are some uncertainties about how or whether it would be triggered. I think I just wanted to touch real quickly because I know that I think a lot of the conversations that we're having these days have a lot to do with the core challenges and also with some of the First Amendment findings regarding compelled speech, and we'll touch on those lightly. But I think one of the take-home messages is that we can't allow that for that uncertainty to cause any sort of paralysis in terms of actually preparing for those eventualities. Okay, I apologize. I need to briefly stop on this slide, but I think we can actually use it as a decent segue to an important point. It's the standard disclaimer and limitations, and we're unable to provide professional advice. But I think it resonates with the key concept for compliance under Dodd-Frank, because the rule is a principles-based regulation more than it is a rules-based regulation, meaning that it does not prescribe specific approaches to compliance, but rather it provides a set of guidelines and principles within which companies can develop their own compliance approaches. So that gives you some flexibility, but there is initially a higher level of effort in designing an approach that matches your company's facts and circumstances. It's not one size fits all, so that's a big part of why even if we wanted to, and we're able to, we couldn't actually rely on a slide deck to provide advice. I would add that EY has been tracking the conflict minerals rule from the beginning, and that we've advised quite a few clients on their compliance programs and their audit readiness. And that means many of our professionals have served under different clients, and they've seen those different facts and circumstances. So even if I spoke authoritatively for EY, I wouldn't actually be able to speak for all their different experiences. So therefore, we had that first bullet. I think we're mainly going to focus on the next couple of reporting cycles. I think that's what everybody's thinking about mostly. Worrying about it is probably not too strong of a word, because the potential future audit will come into effect next year. But past this prologue, so we'll briefly touch on the drivers and how they provide the context for compliance programs. And we'll also look at some of the lessons we've gathered from the market's experience with the first year of compliance. And then we'll do a little bit of looking forward, 2015 particularly in mind, and we'll discuss the next steps. So looking at the drivers, the drivers is about understanding the context your organization is operating within as it pertains to conflict minerals. Obviously, compliance with SEC requirements is a prominent driver, but by now we all know the implications of the rule extend beyond that. A classic example is a lot of privately held and non-U.S. registered companies saw that only U.S. SEC registrants, meaning publicly traded companies on the U.S. securities markets, were subject to the rule, and a lot of those companies, understandably, didn't read any further. I'm not sure I would have either if I weren't in this space. The rule and its underlying are fairly dense stuff, but I think we all found out pretty quickly, no matter where you are in the supply chain, especially as companies, large privately held companies and tier 1 suppliers of those companies, that everybody's in this together. So unfortunately, some of that delay led to a failure to understand how the drivers for public companies translated into drivers for private companies and tier 1 plus suppliers, mainly because those latter groups felt that the rule did not apply to them. regardless of the public or private status, however, the drivers can still be described in terms of risk and identifying and formulating a response to it. Public companies are of course, thinking toward their disclosures made to the FCC, and also in terms of what their stakeholders will see in their disclosures. And those stakeholders can be in the capital markets as investors, or the consumer markets, or you can also think in terms of non-governmental organizations. Don't want to jump ahead too quickly, but I think that third bullet point there, Rob actually talked about it pretty convincingly, I think. Even if the conflict minerals rule were overturned in the courts, for example, it's actually not it's not an option. The SEC does not have an option whether or not to promulgate and to enforce a conflict minerals rule. So, as part of Dodd-Frank Section 1502, Congress said that the SEC had to promulgate a rule. They drag their feet. They take a while to do it, but they were obligated to do it, and they did. And even if it were struck down, they would just have to make another rule unless Congress amended Dodd-Frank, which is an even lengthier process than the court battles that we saw. And furthermore, as Rob said, there's other track and trace style regulations, and those should not be excluded from your consideration of drivers. REACH and ROHS, or ROHS, or ROHS, however different folks pronounce it, and the European Union's conflict minerals legislation are good examples. And for these large companies and large SEC registrants, but also large Tier 1 suppliers, these multi-jurisdictional regulations to affect them. The fourth bullet here, the key word here is repeatable, and 2013 is not repeatable. The level of effort that was required, that we all saw and experienced in 2013, is not sustainable over any amount of time. And we say that in the same breath as saying that the approach needs to be holistic, which means, which tends to suggest that we need an expanded approach, and that the level of effort should actually be expanded. But that's the idea, kind of melding the third and the fourth bullet point together here, is that your efforts can be more than the sum of their parts, if you will. Taking a holistic approach can actually pay off over the long term, and it can make even near term being just a year or two, it can make your lives much easier if you design a good approach at the beginning. And the last book is a common kind of truism now, and sustainability especially. If you can't measure it, you can't manage it. You manage what you measure. But to that I would add, if you don't tell your story, somebody else will do it for you. So I would encourage you to keep that in mind in terms of conflict minerals compliance, insofar as the disclosure-based regulation. Okay, let's jump into some of the lessons learned. We observed quite a few Year 1 compliance efforts. Particularly, I think the lessons learned, the most actionable lessons learned, are in the reasonable country of origin inquiry, or the RCOI, and the due diligence phases. Again, at its most basic functional level, the rule is an exercise in identifying and responding to risk. Due to the complexity and the depth of most supply chains, there's little opportunity for direct observation of risk factors, as a lot large public company, it's very hard to have a first-hand view down the supply chain. And that depth that Rob mentioned and John mentioned in the opening, it's very hard to achieve without a very unified, concerted effort. So those public companies that follow conflict minerals disclosures with the SEC, they're relying on their suppliers to identify risk before they have any hope of responding to it. So I think one of the key lessons here was the importance of communication. We heard a lot about that, but about communication. But I think that communication has to, in conflict minerals, has to be fairly constructive. You need to constructive towards a certain end. You need to provide communication that helps suppliers understand the context of the overall compliance effort, so that they understand what the end game is and why you're asking for what you're asking. And in that process, we've seen a lot of participants. They're building supplier capacity, but it's also building of mutual capacity to identify and communicate the presence of risks. By helping suppliers help themselves, they also expand their own capacities. From a private supplier's point of view, let's say they're in the supply chain of a large public company, and they want to generally they want to mitigate the risk of damaging the relationships with their publicly traded customers, and that risk that does cascade down the supply chain. So the point of leverage is often something that comes up. Let's say a publicly traded company is trying to push a policy or a practice down the supply chain. Obviously, it has to go through subsequent tiers of suppliers, and the point of leverage is generally viewed as only one tier away from the issuer. But that's a year-over-year type of effort that we've seen designed into programs to very good effect. It's only a year or two, so we haven't seen it happen, but it tells a very convincing story in terms of the actual filing. I want to touch on a couple other points before we move on. Regardless of how reporting is affected, or whether your company is directly affected by reporting requirements, fully characterizing and communicating any of the risks identified is key practice. I don't want to belabor the obvious with the second bullet point, but I would highlight the risk that data received through the RCOI process can be suspect. And the burden for conducting sound due diligence on that data exists at each level of the supply chain. The regulatory burden, of course, is only on the SEC issuers and registrants, but they certainly expect their Tier 1 plus suppliers to collect good information and convey it back to them, flow it up to them, so they can roll it up and report accurately, because they have to sign off on this stuff. And as an SEC regulation, it has a bit more teeth than some of the Environmental Protection Agency regulations, for example, that might result in a small fine, securities and exchange liability. The system of red flags used to identify potential risks does not have to. I think that's a common misconception that some system of red flag logic has to be applied in some sort of Byzantine way. But the rule is generally interpreted as allowing for a risk-based approach. To identify and respond to different categories of risk. So not all risks need to be treated the same. You just need to make some of this determination and then stick with them. allocate towards the higher priority risks. Disclose a different exercise at the moment. So the logic underlying those red flags could be fairly straightforward. And I would also touch on the importance of data integrity. If suppliers are providing inaccurate or incomplete data, that's a fundamental red flag, whether you call it a red flag or not. It's got to be complete. It's got to be accurate. And in terms of testing its accuracy, I mean, it is a starting point. And if there's blank fields, then it undercuts the whole process. We've seen programs successfully rely on different mixes of technology and manual-based approaches to actually executing both the RCOI and due diligence phases, but the documentation process, I would say, invariably relied on some kind of technology platform. And to quickly tie this together, consider that for risk-based approaches, that SEC registrant's level of due diligence effort can be commensurate with its chosen approach to risk prioritization. Keeping that in mind, within the OECD framework, the due diligence measures are fairly flexible. Regardless of which measures you choose, especially applies to publicly traded companies. The reporter should keep in mind that ticks of the situation in their disclosure. We'll circle back to this, but just suffice to say at this point that the reporter has to be aware of reputational risk as well, and whether they're actually making disclosures at a level that will satisfy all of their stakeholders, not just the regulator stakeholder and not just their customer stakeholders, but also for example, NGOs and other kind of watchdog type groups. One of the broader takeaways from year one compliance was the need to increase compliance with a multi-year perspective, particularly with regard to due diligence. RCOI is an exercise that it's not entirely inappropriate within a single compliance year. A lot of registrants have made commitments to building their internal capacity to an increasing proportion of their supplier base and meet successive RCOI, and that's a good practice. But the RCOI is typically limited just for practical purposes. So I would emphasize that risk mitigation and due diligence efforts can benefit from the multi-year perspective more so. We see some aversion to the notion of increasing due diligence intensity year over year, but I think this is largely based on misconceptions that the corrective action within due diligence has to involve reduced engagement with suppliers. And we all care about our suppliers. We don't want to terminate relationships or suspend trade with them. I would say one of our observations is by including even important suppliers within corrective action, it actually has the opposite effect, particularly in these early years of compliance. The risk that suppliers fail to understand the rule for their customers' conflict minerals policy is the top risk. Therefore, increasing supplier engagement with these suppliers is a viable form of corrective action. So, for example, reaching out to the suppliers on an increased basis relative to more compliant suppliers is to provide training and increased communication is a best practices that we've seen in year one. And I would wrap up this slide by just mentioning that documenting that increased communication and training is another key practice that we've seen used to very good effect. looking back at, jumping into reporting and looking back at year one, it was a fairly volatile year. Not much basis for comparison, but I can't imagine that it will continue to be so volatile with court rulings and gradual clarifications released by SEC over time and so forth. One of the lessons learned is to avoid letting uncertainty lead to paralysis. Again, you measure what you manage, or you manage what you measure, but you can only manage what you can control. And I think we saw an example of that, of a misstep with issuers that delayed compliance efforts because they were waiting to see what would happen with the appeals court rulings. I think they were generally disappointed in the rulings, and as a result of their delay, they found themselves behind schedule. And there's similar uncertainty with the audit. It's not entirely clear what will trigger the audit now that companies are no longer required to make a declaration in terms of using the specific terminology of conflict minerals undeterminable and not found to be DRC conflict free. But I think we can look back and learn a lesson from that court ruling and see the value of advanced preparation, regardless of what we want to see actually come of the next as an outcome of that delay in clarity on the triggering the audit. Year one, we saw about 1,300 companies file a Form FD, which is more than slightly less than the 6,000 companies the SEC projected would be affected. Interestingly, the SEC also projected that about 75% of Form FD filers would also file CMRs, so that would be 4,500 companies that were expected, and instead it turned out to be much less than that. But the percentage wasn't far off. So I think they had some sort of sense of the proportions. It very well could be luck, but found that closeness and accuracy interesting. So the balance being discussed and referred to in the second bullet point there's a couple of different balances really, and of course it's all tied together, but it depends on how you want to break it down. It's striking a balance between actually meeting your regulatory obligations and to the extent of regulatory compliance, and actually balancing that with your stakeholders' expectations. And this is a tricky balance because there's always a bit of tension between disclosure, controlling the story, and limiting transparency. When I said if you don't tell your story, somebody will tell it for you. That cuts both ways. The more you disclose, the more you're telling your story, but at the same time you're also sometimes providing more information than you're comfortable with, and that's a standard problem. But keeping in mind that the spirit of this legislation had a lot to do with transparency, you have to think about what your stakeholders' expectations are with regards to that transparency. Another aspect of that balance is in your disclosures, and in this, if you're a private company, in the disclosures of your public company customers, they're going to have to disclose information that meets both those regulatory and stakeholder expectations, but also using language that's auditable. So everyone's going to have to think in terms of just the facts. Avoiding language that's not quantifiable, testable, is a really important practice. There's some practical debate over how to distribute information within the filings, and I'm not going to immediately go into that, but we can perhaps circle back to that. But only the conflict minerals report is subject to the audit. Keep that in mind. Form SD is not auditable, but anything that goes into the conflict minerals report, you have to think about whether it will or will not be subject to an audit. And so, of course, you want to make sure that anything in there is prepared to be audited. So just avoid superlatives or marketing. You can think about it in marketing type language and stick just the facts. Just don't want to say you included a whole lot more suppliers in your RCOI process this year, and you're very proud of that. We're not going to be able to audit whether or not you're proud of that, and a whole bunch is not. It's a very relative term. So stick to just the facts. And also keep in mind that that the independent private sector audit will include 2 audit objectives. The design of the due diligence will be compared to the OEC. The design of your due diligence, as you describe it in your CMR, will be compared to the framework, due diligence framework put forth by the OECD. And that's the only framework that's out there right now for comparison purposes. And then the second audit objective is probably the more familiar kind of approach to auditing. It's comparing the description of the due diligence measures that you undertook as you describe them in your CMR, and comparing them to the actual due diligence measures that you undertook in your program. So you can imagine the type of documentation that you might want to have ready to prove that what you described and what you actually did in terms of due diligence. Speaking of documentation, this last bullet point goes into the next slide just as well. You're going to want to engage with your independent auditor before you need an audit. This is a best practice that we've seen, and it's one that surprises some folks because sometimes they think they can't talk to their auditor in advance of the audit, and that's true. The auditor will not be able to advise in any significant capacity on your actual program, but you can talk with them in many cases about what kind of documentation they would expect to see, and start getting together, start coordinating how you would provide that documentation. So speaking of documentation, there are a couple of key aspects for preparing documentation. One of which is preparing for a filing versus preparing for an audit. These two preparations would do overlap considerably, but I think it's an important distinction to keep in mind. Preparing for a filing, you're going to have a lot of aggregated data, and you're going to be putting aggregated figures into your actual Form SD or CMRs. But an auditor would need to see the actual source data that you use to prepare that information. So keep track of everything. Maybe have an aggregated figure. Make sure you know how to explain where that came from. I've got a few examples of classic materials that you'll need when you're when you're preparing your Form SD and CMR, but also it's a good opportunity to gather up other records that that an auditor might want to see that are additive to the other documents. Conducting a readiness assessment or gap analysis, we've seen a lot of value provided there. It's just, my good colleague says, surprises are for birthdays, not for audits. And I think the gap analysis approach is a good way to think about it, whether or not you bring in outside help or whether you have internal resources that are independent of the actual program conduct a gap analysis. You need to keep that in mind. It's really a great opportunity for preparing for an audit, but also for preparing for disclosing a lot of information about your activities to the public. A bit of uncertainty, and I think the take-home message here is not to let that uncertainty cause sort of this within your program. Let me make sure I didn't jump 2 slides. Okay, I did. Good. So with the unknowns, as far as just a bit of the found unconstitutional the certain disclosure aspects of the rule. Basically, they upheld all of the rule except for parts that required that were found to compel speech, which they found unconstitutional under the First Amendment, and that specifically caused the requirement within the rule to make a declaration of not found to be DRC conflict-free and undeterminable. Those requirements are no longer required, and so therefore they're not available to trigger an audit in the case of the declaration that you're not found to be conflict-free. Companies can still voluntarily make the declaration that their products have been found to be DRC conflict-free, but that's strictly optional. Incidentally, that would trigger an audit, but we'll have to see how many companies actually end up doing that. Only 4 companies, and 1 actually sought out an independent private sector audit, and so there's some data points along the lines. But going back to that uncertainty, do not allow that uncertainty to cause paralysis in your program. You still want to engage your stakeholders now to determine the future direction of your program. Expectations are increasing with each successive year. The regulatory expectations certainly are. And I would say that increase extends to customers and NGOs. And that you should definitely consider part of your stakeholder engagement, engaging with your company executives. We threw this in here because this is an SEC reporting requirement, and therefore the attendant liabilities are a little bit really have the attention of corporate leadership, because there's a provision that the corporate officer must sign off on that, and that's a fairly high level sign off, and that makes people nervous. They want to engage with internally pretty aggressively and well in advance. I think Rob covered it well, but there are already in existence other track and trace regulations out there, typically in different jurisdictions. but we've seen others in the U.S. The automotive industry had the IMDS regs that required them to disclose the material specs within all of their parts, and they had to build a system that's not terribly different than the technology solutions that are available for conflict minerals. Unfortunately, it didn't fit exactly together, but the companies that were already subject to that regulation, the INDS reporting requirement, actually were relatively well prepared for, they understood conceptually how it was going to work with designing a strategy and implementing a strategy and integrating a technology solution into their organization. So we do have U.S.-based case studies for disclosure requirements, but that's the past. I mean, I think it's predictable. I think it's safe to say that smart people in a lot of places are saying that we can expect more regulations of this sort. We call them track and trace regulations in many cases because it expands the obligation to account in your supply chain. Again, build that capacity to track and trace as a function of general supplier engagement, and or as a part of corrective action undertaken during due diligence. On the second bullet, the key word here is holistic. Holistic does not have to mean expanding your effort. It actually is intended to avoid surprises. If you expand your perspective beyond your compliance efforts and apply this to your overall strategy, we've seen that has helped offset some of the uncertainty that the conflict minerals world has struggled with. Take advantage of the opportunity to learn about your own supply chain and risks. A robust initial effort can help prepare for future regulations, and that feeds in to your overall strategy. And keeping with a holistic approach, that last bullet, we talk about it a lot, but we've seen really getting it, if you will, but fine. The regulatory landscape, using an understanding of your own and a one-size-fits-all approach. To peruse the resources that are available on our website, and of course that of Green Status Pro, and certainly feel free to be in touch if you want to discuss further. And that concludes what I have to talk about today. I'm looking for John's thoughts on the topic and looking for questions. Yeah.
Thank you very much, Anthony. That was very insightful as to the status of where we are in the conflict minerals process. Now, what I'd like to talk about, and I know we have a limited amount of time left, is the crisis that we've got on the RCOI reporting at this point in time that's been triggered by CMRT version 3. It's, in my opinion, 2014 will be the most difficult year ever for conflict minerals reporting. And the major causes of these challenges will turn out to be this version 3 of the CFSI CMRT. Let me show you why. First, responsible. That's the theme we have. Responsible, and responsible means accurate. We have to be responsible to our customers because we're passing information to them that they're passing to their customers. Our information has to be accurate. Our filers are going to want higher quality CMRT starting on November 1st for the year 2 reporting. Our information has to be accurate because it has to be audit-ready quality for SEC Form SD. And the SEC's Director of Corporate Finance on September 12th has stated the SEC is likely to start examinations of companies after the current Court of Appeals clarification is made. And we have to be accurate because it's our company's credibility and brand reputation. We don't want our companies to take a chance because of conflict minerals to be branded as somebody that doesn't quite tell the truth. And for those of you who have spent so much time working on the conflict minerals role, there's this objective of reducing the funded violence. And we're not going to be able to do that if it's undermined by inaccurate reporting. Accurate reporting is a requirement. And now we have the CFSI, and that is critical for accurate reporting because they're the authority responsible for conflict mineral supply chain reporting. Our Department of Commerce in the U.S. has clearly stated it's not going to fill this role. The CFSI CMRT is the industry standard for 3TG supplier to customer reporting. Continuing on, the standard smelter name worksheet is the industry standard. The smelter audits are the standard. But accurate reporting requires both CFSI providing accurate data and our CMCOs, conflict minerals compliance officers, using it correctly. We both have to be responsible in this perspective of going forward. How's that working? Not well, because the supply chain data is sloppy. Too many smelter entries are simply inaccurate, incomplete, or inconsistent. I'm going to show you that in the next slide. And when we talk to the CMCOs, they consistently state that their number one RCOI reporting challenge is managing the smelter data provided by their suppliers. When we run, for many companies, their CMRTs from their suppliers, we'll have a rejection rate of 40% of our customers' supplier smelter entries rejected because they're inaccurate, incomplete, or inconsistent. And so many companies that are doing copy and paste into do data entry instead of the pull-down menus as they're created are providing corrupt entries. A call to action and best practice. You must reject your supplier's CMRTs that contain corrupt data. You got to send it back to them and say, this is unacceptable. We can't operate in this manner. A best practice for moving forward. But within that, let's take a look at what's happened with version 3. Here's an example of a sloppy data entry. We have tin. This is a real live example. Smelter not listed. Oh, so they put in Gold Bell Group from China, but there was no smelter ID, so they didn't put it in. Now, many of you out there are going to say, well, pragmatically, I just find the smelter ID from another form and put it in here. And what's happened is we'd say, no, 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 you can't do this because we see that we've got the lack of a smelter ID. We reject it as an invalid smelter ID form. What's important is the rejected entries report that we create pinpoint suppliers with whom communication is important. Now hold on for 2 slides. I'm going to show you why this is actually very important. Because with the introduction of CMRT, we created a major challenge to this accurate reporting. Because we can't mix suppliers versions 2 and 3 version 3s. If you look at the summary of the smelter changes on version 3, 33 of the 200 standard smelter names published in 203A were changed. 20 tin smelters were removed, 3 gold refiners moved, 2 tungsten. You can read the report. And then we changed the names of smelters and refiners. So what happens? Well, let's look at the example of why this creates chaos. Here's our entry that looked so simple. Smelter not listed, Gold Bell Group China, no smelter ID. Whoops. When I go to version 3.0, there is no Gold Bell Group. What happened here? If I go between these two, I simply find that Gold Bell Group has been removed. But CMR version 203 did include the Bell Group. Here we have the metal tin, Gold Bell Group, known aliases, facility China, and we do have a perfectly good smelter ID. But if we put forward the Gold Bell Group, and our filer continues to do it, they'll have incorrectly put Gold Bell on their CMRT, which is not correct anymore. It's been removed. Wow, this is a problem. And then to make it a little more interesting, and this is more of a less important nature, but when we've gone through and checked in the past, we'd go through and we'd use the former IDs where there was metal and country. In other words, We knew that 1 meant gold, AUS meant Australia, and very quickly you became familiar with the system. So you would know what the smelter ID was with comparing it to the metal in the country. But what happens now when it's randomly assigned? We don't know what it is, and now we have to go and check the smelter ID. So another area where we're building inaccuracies into the system. Bottom line, and I can open this for questions and still see how we're doing on time. Reality is, you're going to have to manage mixed environments of version 2 and 3. Our best practice is your focus has to be on accuracy. But manual methods are going to be error-prone, time-draining, and require unacceptably long turnaround times. That is between when you get a CMRT from a supplier and can add it to your information and provide your company CMRTs. As Anthony said, to support your customers, it's going to take too long. And the resulting reports, if they're not accurate, may fail your audit and or when the SEC comes in, their examination. The point I'd like to make is automation is the only realistic approach to managing the current chaos and confusion in conflict minerals reporting. You got to have rules-based validation of the supplier CMRTs. You have to do smelter consolidation of the correct data. That is, clean data goes into the smelter consolidation reports. You have to have a rejected entries report for which you do your due diligence to go back to your suppliers and say, look, this has got to be corrected. And we constantly have to keep for your records the current smelter CFSI audit status available. Thank you very much, and I'd like to open this up to questions and answers at this point. And Anthony, the first question comes right to you. Do privately owned companies need to report this information, referring to the RCOI and due diligence information?
No, that's an easy one. They do not have to report to the SEC. They need to report insofar as their customers request it. If they're selling a product directly to consumers, that's not what I'm talking about. I'm talking about if they're in the supply chain if they're a supplier to a company that does need to report, then it's in their market interest, their customer relationship interest to report. But otherwise, no, the conflict minerals rule does not apply directly to private, non-public companies.
But they have to report, now let's go back, they have to report to their customers who are filers, and they have to, and you're telling the filers they have to go deep into the supply chain. So while they don't have to report, what's your perspective on how accurate they have to be in maintaining the data and having it available?
Oh, in terms of the exercise, if they are in the supply chain?
Absolutely, when they're in the supply chain. Private companies, overseas companies?
Yep. Yeah.
Yep, means they have to really have that data accurate, don't they?
That's right. They have their customers are relying on them to provide accurate and complete data.
And the follow-up to that by the same gentleman is, are third-party audits required to be done from our supplier to the smelter level? Anthony?
Oh, I'm sorry.
Are the third-party audits required to be done from our suppliers to the smelter level?
No. The third-party audits that we're discussing today have to do with the rule. And the audit objectives, as I described them, are simply the only entities being audited are the publicly traded companies, and the only thing that's audited are the contents of their conflict minerals report. And the only objectives of those audits have to do, they're very limited objectives. They have to do with the design of the due diligence framework that you used, and whether or not that conforms with the internationally recognized due diligence framework, and two, whether your description of your due diligence measures are actually in alignment with what you the measures you actually undertook. If you should describe in your due diligence measures some sort of activity that involves the smelters down to a certain level, then yes, that could possibly come within the audit objective too. But you might have to work to do that, and I don't think it's a standard consideration.
Rob, we got a question here on the big picture. Okay, can you help us better understand the negative impact the disclosure of the use of North Korean gold had on any company?
Sure. First of all, it really affected the 68 companies involved quite directly, and all the other companies, the other 1,300 companies, indirectly, and by form of relief that they weren't involved in it. But at this point, the SEC has not charged anyone, and at this point, the modifications have been made. Amended Form SDs have been prepared. So the major impact had to do with the confusion, time, focus of those 68 companies, the C-suite directors, and the compliance efforts to figure out the problem and fix the problem.
Okay, well, I think we've run out of time. Thank you for joining us today. Well, this concludes our session. If you have questions we haven't been able to answer, please feel free to follow up with any of our presenters. As you can see, we have all their contact information, and we'll be emailing this information to you promptly by tomorrow.